If you already have an established child custody order, whether that comes from a divorce case or just a child custody establishment case, and you want to change that after the fact, there's some very important things that you have to remember before moving forward, because there's some consequences if you don't have the required evidence. So if you want to change your custody order after the fact, a year, 2 years, I've done it a couple months afterwards, the standard that you have to meet is there's got to be a permanent, material, and substantial change in circumstances that's happened between one or both households to justify modifying the custody order. Now, it's not a very high burden, but there has got to be something that has taken place from the date that the prior judgment was put in place to today. Now, a lot of examples that you can look at as far as what actually amount to a substantial, permanent, and material change of circumstances is one of the parties got remarried, one of the parties has moved, one of the parties has moved out of the kid's school district, so they have to go to a different school, and the parents can't agree on where the kids should go to school now. There's been some significant substance abuse in one of the households. There's been some mental health breakdowns, whether that's between the children or one of the parents. Some of the kids have some mental health issues such as anxiety, depression. In one of the parents' households, due to what's going on there, the kids are suffering academically in one of the parents' households. Some of those issues you have to kind of stack on top of each other to actually show that there's been a permanent material change in circumstances. One issue that the court will look at is the wishes of the child, because that's what they have to look at when they're modifying or establishing custody as far as what's in the best interest of the children. The court has to look at that list of factors that the statute has. One of them is the wishes of the child. However, when you're looking at that, you have to be very specific, and you have to actually stack that one on top of one of the other ones. Some of those other ones, them in and of itself, will justify modifying the custody order, but the wishes of the child is not something that can stand alone to establish that there's been a permanent material change in circumstances. There has to be something other than just the child wants to leave. So when you're asking yourself, do I want to modify this child custody order? You got to figure out, do I have permanent and material change in circumstances that would justify that? Because that's the bar that you have to reach before the court will even consider actually changing the custody schedule, and if they should change the schedule. And they'll go through those same factors that they went when they established it in the best interest statute, which is wishes of the parents, wishes of the child, interaction and relationship between parties, the children, their community, the character and circumstances of all the parties involved, whether it's been domestic violence. They'll look at all the factors. They're going to look at everything as a whole to figure out what the best interests of the child are and what the new custody schedule should look like. But you can't even get there until you establish that there's been a permanent and material change in circumstances. So if you're looking at changing your custody order, you should plan early. You should get the evidence that you need to show the court that there has been that change that requires that the custody order is changed so that kids can be in the best possible place in their life and moving forward and growing.